My name is,
Mr. Dunmore.
as you know, I appear with Mr. Popplewell for the Appellants, AA and others.
Yes.
My learned friend Ms. Gray is from
Yes,
NHS England, and the interested parties aren't represented, though I understand they have eyes and ears and calls.
Yes, certainly.
Now, this is that most unusual of case, a case raising but a couple of really quite crisp points of law against an entirely non-contentious factual background. In terms of housekeeping, I hope you've got the supplementary materials we filed. They're actually better versions of some of the documents already in the authorities bundle.
Now, just a moment. I have got my... sorry, I just misplaced from my supplementary authorities bundle, but I have it. Thank you.
We've also got copies of the case of Tandy that
Yes.
my lord identified, and a further case, if necessary, that's been provided to my learned friend, Miss Gray.
Just before you get up to speed, Mr. Delamain, may I just remind everyone that there's an anonymity order in place in relation to the juveniles, the minors, children involved in this case, and so just so that everyone is aware that they must not be named or identified in any way.
I'm grateful, my lady, and perhaps because of the public interest in this case, it's also worth reminding everyone that live streaming is attended by the usual rules on contempt for those who might.
Yes.
Grateful, my lady. So, the single point we raise on our appeal is that the judge's core conclusion, which is that Regulation 45.3 of the 2012 regulations is in effect a mere target duty, is wrong. And that being so, we seek, as we sought below, a declaration that the NHSE compliance with the regulation properly construed is in breach of their duty. We bring this appeal with the permission of the judge, who fairly recognised both the arguability of the point and its public importance. And my learned friend is making an equivalently crisp argument that the regulation properly construed only applies to consultant-led services. In terms of the judgment, it is, I would suggest, an immaculate, careful and sensitive summary of the relevant facts and the clear background against which these questions about the status of Regulation 45.3 arise. We have little, if anything, that we want to say on that subject. In particular, the key passage is actually 31 to 33, which deals with the position in relation to waiting times for services provided by NHS England. That's addressed at 31. The position in relation to child services is addressed at 32 and 33. And of course, I'm sure the court is live to the fact that because of the issue raised by my learned friend's cross-appeal, the delays in the non-consultant-led child services are not included in the NHS England figures. So the NHS figures are predicated upon an assessment exercise that wasn't in accordance with the duty as the learned judge described it. So the core point is whether or not Regulation 45.3 creates a hard-edged and enforceable duty. And whilst the point arises in connection with the GID services that NHS England alone is responsible for commissioning, the significance of the point has really quite a bit further, wider reach in at least two respects. The first is that Regulation 45.3 applies to all commissioning bodies, all relevant bodies, whether they are NHS England or one of the plethora of what are now called ICBs, formerly clinical commissioning groups, and thus to all forms of treatment in which an elective referral is made, whether or not consultant-led, if the judge is right in relation to that point. So that's the first aspect of the reach of the point. The second aspect of the reach of the point is that much of the judge's reasoning applies with equal measure to many of the other standing rules contained in the 2012 regulations. Part 9, which is what we're concerned of, is but one cluster of such rules amongst others. And all of the standing rules are, in fact, as we shall see, intended to give effect to what are described as rights under the NHS Constitution. Many of those rights are expressed in similar language to Regulation 45.3, And they are all, as we shall see, intended to affect the allocation of resources. The apogee of that, perhaps, is Regulation 38, which is the requirement, the right, to have drugs recommended by NICE made available for your treatment. And we'll see the language of that section is very similar to that of Regulation 45.3. And if the judge's reasoning, which is in very substantial measure moved by resource allocation considerations and the impossibility of framing mandatory relief because of the interference with the process of resource allocation, if that's right, then that reasoning seems to reach deep into the wider contents of these very significant regulations. Our case, of course, is that this is in fact a specific duty imposed through regulation-making powers that are designed to clothe what are target duties, the provisions of the NHS Act, with enforceable flesh. They are regulations that impose identifiable duties of end obligation of result. That's the structure of what is at issue here. It's an obligation through the commissioning arrangements you enter into to deliver a service of a certain quality, with the metric of that service quality being clearly and carefully provided, both by the terms of the regulation itself and by reference to the guidance which is given effect in relation to it through Regulation 50. Now, the complication in this case, and it may well be a factor that goes to the appropriate form of relief, is the impact of COVID on the National Health Service. We can't hide from that, even though the statistics show that even before COVID, NHS England was in breach of the duty as we conceive it. The position is markedly worse after COVID. But our simple answer to that is this: such a problem was anticipated as long ago as 2010, when the directions that first embodied these rights were made. Even at that juncture, an influenza epidemic was anticipated, and it was anticipated that if that occurred, it may be the case that the obligations in question required to be suspended. And that's ultimately our answer to much of what the Secretary of State says. If the real complaint is we can't comply with this duty now in these changed circumstances, the proper response to that is not to pretend that the law is anything other than it always has been, but to change the law. If that means that the NHS constitution and the rights it contains must be altered, the waiting time right downgraded back to the status of a pledge, which it formerly had, as we'll see, so be it. But what you can't do is to pretend that a network of obligations clearly designed to confer legally enforceable rights is anything other than a hard-edged duty.
How does that work in practice? Suppose that, hypothetically, the 92% is being achieved at the end of a particular calendar month, and then COVID strikes. You're not going to get the regulations changed, are you, by the end of the next month?
Well, the time...
Take something less dramatic. There's some particular problem with staff shortage in one particular area, which means you're going to dip down to 91%. You're not going to get the regulations changed, are you? Well, you're simply going to find that the NHS England is in breach of duty.
Well, with respect, that question raises exactly the same types of issue as the court has grappled with in other cases, like, for instance, the Client Earth case, where there is a clear obligation of end result. In Client Earth, it was in relation to air quality. The achieving of that end result is highly complicated. The question is whether or not it's appropriate for the court to roll up its sleeves and to set an enforcement plan or milestones by reference to which the particular obligation is to be achieved or not. That is a proper topic of inquiry if a party is seeking that form of mandatory relief. But we're not. We're content at present to rest upon a declaration in the knowledge that the Secretary of State will take that declaration and their duties under the law into account and use that in order to shape what steps next are appropriate to address the breach of the law.
I was on a slightly different point. I think you were saying, well, it's said against you that if this is an absolute duty, NHS England might be put in breach of it through circumstances entirely beyond its control. To which your answer is, if those circumstances arise, it can be prevented from being in breach of duty by a change in the law. And what I was just questioning is whether that is practical in all cases.
Well, with respect, my lord, that is a question for the Secretary of State. If the Secretary of State finds that there are circumstances in which there is an evanescent breach, a temporary breach which is not thought to be material, not thought to require remedial response, then in my submission, the appropriate way to respond to that is to tailor the terms of the regulation and the duty that it imposes. And what the regulation certainly does do is specify in certain specific circumstances some forms of concrete remedy that are required. And the most obvious is in relation to regulations 47 to 48. When they're capable of application, they provide an individual right effectively to change provider to one tenuously providing the service. It may be that the appropriate response to a general breach of the kind that will be caused by regulation 45.3 is further specification as to the remedial consequences of that breach. But the logically prior question with which you have to grapple with is the Secretary of State in breach of the relevant duty? That's the first question. Now, that leads to this final introductory point. The law on target duties, which I'll go through carefully by reference to the Ali case, etc., has been hitherto pretty much fixated with or concerned with high-level target duties of the kind that we see in Section 1 or Section 1A of the NHS Act. It has not been concerned with regulations or directions that have been made in order to flesh out those target duties. And what is, so far as we can see from a review of the law, a unique characteristic of this case is that we are concerned with a regulation, and before that, directions, which were intended precisely in order to add flesh to the target duties in Section 1 and 1A and so forth. In circumstances where the Court of Appeal, and I'll show you this passage in Lord Wolfe's speech in Ali, identified the making of the regulations, or directions as it was in that case, as being the act which would transfer what might otherwise be a substantially non-justiciable dispute into a justiciable dispute, because the directions or regulations would create enforceable obligations. What's really striking when one stands back about this case is it's being said that notwithstanding the directions and regulations made, nevertheless we're dealing with a second order or downstream target duty. It's like you've got the general target duties in Section 1 and 1A, and this is a slightly less vague, but still nevertheless legally unenforceable target duty. And there is
some of the regulations are target duties. If one takes, for example, 47 to 49, the obligation is to take reasonable steps to find an alternative provider. Some of Regulation 50 says must have regard to, which is perhaps the classic language of process rather than achievement. So I quite understand you're saying that in the context of waiting times, this is the flesh which is intended to take it from a higher level target duty to an absolute duty. But the fact that it's in regulations doesn't necessarily carry all that weight, does it? Especially where the regulations also have specific target duties.
It's not dispositive. It's highly legally significant because it shows what is the intended effect of the relevant regulations, what their purpose is, which must be a factor that is of relevance in deciding whether or not one is grappling with a target duty or not. Of course, we agree with the judge ultimately. It's a question of construction. And of course, my lord is quite right. There are passages in the regulations that do use language more redolent of target duties. Those passages are in fact in Part 3, as I'll show you, where the language of the kind my lord has identified, reasonable measures, etc., which is more redolent of target duties, is used. What's conspicuous by its absence is that language in the wording of the relevant standing rules, including in particular Part 9, which is what we're concerned with. Now, the reason why reasonable opinion type language is redolent of target duties goes to the essence of what a target duty is, as the case law shows. What it really is a duty that entrusts so central an evaluative task to the decision maker, such that there is such a range of different ways in which the duty can be discharged, as to create a justiciability problem for the court, because the end result is vaguely specified, and all that is specified is that the decision maker has a difficult job of resource allocation in deciding how to compete between different factors in the achieving of that aim. That's why reasonable opinion type language is a flag for something that looks like a target duty, and why its absence, coupled with a cold hard 92% metric, is so very significant. So with those introductions, can I take you through the legislation fairly carefully? I am, to save my learned friend some time, going to very carefully, I hope, and correctly refer to each and every instance of the occurrence of the word consultant-led in the relevant background documentation. And you'll see, I can only fairly concede, there is a plethora of such references in the background material. Let's
and we're using consultant-led in the statutory interpretation to include interface services.
Yes.
And then we don't need to mention them again.
Absolutely. Agreed. So, can we start with the 2006 Act at tab 1 of the Authority Bundle? This is after the very substantial amendments made by the Health and Social Care Act 2012. This Act, in my submission, for our purposes, does 4 things. Let me flag what they are in advance. First of all, it sets the target duties of the Secretary of State and of NHS England. Secondly, it provides the relevant suite of powers, both by regulation and direction, for the Secretary of State to impose more concrete duties on NHS England, as opposed to ICBs, to commission services. That's the provisions of Part 3 and Schedule 4. Thirdly, it provides regulation-making powers to set standing rules applicable to all commissioning bodies, whether or not it's NHS England or an ICB, as to how they commission and deliver services. That's section 6E. And fourthly, it contains the much modified powers of direction for the Secretary of State and for NHS England. So the first theme, the target duties, you have the duty at section 1 to promote a comprehensive health service, allied with the target duty at 1A over the page, continuous improvement in the quality of services. If one flicks momentarily to the supplementary bundle, you can also see that there is a section 1B after 1A, the first tab, as inserted by section 3. There's an obligation on the Secretary of State to have regard in exercising all functions to the NHS Constitution. That's obviously important when the Secretary of State exercises regulation-making powers. Then 1H...
Just not followed you on the paperwork. We've got in the supplementary authorities bundle other bits of the 2006 Act.
In tab 1, you should have the Health and Social Care Act 2012, which is what, in fact, inserted section 1, section 1A, and so forth. It was Mr. Lansley's very substantial reform.
I'm with you.
And it inserted 1B. As you can see, we omitted that, and I apologise, but what we do have is the 2009 Act, which sets obligations on everyone other than the Secretary of State to take into account the NHS Constitution. I'll come to that momentarily. Then section 1H creates NHS England, as it's now called, and puts it under the duty, concurrently with the Secretary of State, to deliver a comprehensive health service. So that's the first theme, target duties. The second theme, allocation of function as between ICBs and NHS England, is set by sections 3A and 3B. The default is provision of care by ICBs commissioning services, but section 3B allows the Secretary of State to make regulations requiring NHS England to arrange to provide certain things, and you can see dental services, armed forces services, prison services, and then D, such other services or facilities as may be prescribed. And then there are conditions as to how that is prescribed. That interacts with 3A in the manner you can see at 3A3. An ICB may not arrange for the provision of a service or facility under subsection 1 if NHS England has a duty to arrange for its provision by virtue of 3B. So the regulations may entrust particular functions or service provision to NHS England. That's the second theme. The third theme is the regulation making power in 6E, directed as to the exercise of functions by NHS England or integrated care board. Now, the language of this section is, in my submission, highly material because the learned judge's judgment attaches very significant weight to the words make arrangements. That's the vehicle, effectively, for his finding that these are mere target duties. But the wording of make arrangements comes directly from this provision, a point that the judgment does not identify. So you see in 6E1, the regulations may impose requirements known as standing rules in accordance with this section on NHS England or ICBs. The regulations may, in relation to the commissioning functions of NHS England or ICBs, that's crucial because it's obligations in the context of commissioning services, may make provision requiring NHS England or ICBs to arrange for specified treatments or other specified services to be provided or to be provided in a specified manner or within a specified period. But it's then B that's critical for our purposes, particularly in the commissioning context. It may make provision as to the arrangements that NHS England or ICBs must make for the purpose of making decisions as to the treatments or other services that are being provided, and then it's 2 that's of particular significance, the manner in which or period within which specified treatments or other specified services are to be provided. And if you put 2B2 together, you have effectively regulations that make provision as to the arrangements that must be made in relation to the periods in which services are made. And therefore, the language that we'll see in Regulation 45.3 flows directly from this provision.
Is that right? A involves regulations which make provision requiring NHS England to arrange for services to be provided within a specified period. B is concerned with decisions as to what periods might be. So it's arrangements that they must make for the purposes of making decisions as to the period within which treatments or other services are to be provided. So, am I right in thinking that it looks as though Regulation 45 is fulfilling the 2A function, not the 2B2 function.
Well, that might be right, my lord. The point I'm trying to make, and I was going on to point out, is that in C, again one sees this language, as to the arrangements that NHS England or ICBs must make for enabling persons to whom specified treatments or other specified services are to be provided to make choices. So you have it very clearly in relation to the choice-based provisions.
Yes,
it's
the point I'm making may be a point in your favour, because if Regulation 45 is a fulfilment
I see, my lord.
of 2B2, it must be a regulation which was made requiring arrangements to be made for the purpose of, i.e. arrangements with a view to, which would not support your construction of Regulation 45. But
my lord's
as
point,
it seems to me, I'm not sure that Regulation 45 is a 2B2.
My lord's point is that Regulation 45 is a 6E2A provision.
Yes.
Well, like any flexible advocate, I'm going to say that if it's in there, then that's an even further support for my analysis, because it's clearly anticipating concrete obligations as to the time period in which a decision must be made. And if that's the purpose of the regulation, it can't be diluted by the insertion of the words "make arrangements to."
Well, we've got the words "to arrange for" there. We've got "make arrangements to" in the regulation itself. And
anyway,
it's possible they mean the same thing.
It's possible,
and therefore one doesn't really get much out of that either way.
Well, there we have it. That's the varies for the regulation.
Yes.
Which was the next point I wanted to identify. And then lastly, you have the now largely residual powers of direction contained on the part of the Secretary of State in 13ZC and in NHS England in the extraordinarily numbered 14Z61, which is the last provision in the bundle. And the reason these are relatively liminal in content now is that most of the heavy lifting that was previously done by directions made under Section 8 of the old NHS Act, and we'll see examples of that, is now done by the regulation. So the standing rules supplant the purpose that was previously discharged by liberally made directions. The next instrument's the Health Act 2009. This is the act that gives force to the NHS Constitution. It identifies it in Section 1. Section 2.1 then says each of the bodies listed in subsection 2 must, in performing health service functions, have regard to the Constitution. So it's a mandatory relevant consideration in JR terms. And all of the bodies identified are NHS England, ICBs, local authorities, special health authorities, etc. The one person that's missing is the Secretary of State, but that hole is plugged, as I've showed you, by Section 1B, the 2006 Act, as inserted. And then subsection 2.5, every person who, in pursuance of a contract, arrangement or arrangements, makes arrangements, subcontracting arrangements for another person to provide or assist in providing health services, or provides or assists in providing health services under subcontracting arrangements, must in doing so have regard to the NHS Constitution. Now the significance of that is that the NHS Constitution is given the force of law as a mandatory relevant consideration right the way down the chain, starting with the Secretary of State and ending even with the private contracting bodies if private contracting bodies are co-opted into the system. And it certainly embraces all of the public bodies along the way. And the reason that's of relevance is the clear terms of the NHS Constitution, which provide a very clear steering in our submission as to the intended status of the waiting time promise as a right. So,
I'm sorry to keep interrupting you. There's a reference in Section 1 also to the handbook.
Yes.
which I think we've seen somewhere in the material.
Yes.
Is there anything in this Act which imposes any obligations or duties in relation to the handbook?
Not specifically, but I think technically the handbook is treated as being part and parcel of the NHS Constitution.
Not in this section, it isn't. They're quite separately defined.
Well, we'll see. Every time the NHS Constitution is published, it's published along with the handbook, which explains its contents and meaning.
Well, I understand that. And Section 1 draws a distinction between the NHS Constitution itself and the handbook. And Section 2 appears to be directed to having regard to the NHS Constitution, not having regard to the handbook. It may well be that somewhere
it might be in Section 3.
There is such an obligation, but I'm just interested to
Mr.
know.
Popjoy will beaver away while I labour away. But I understand my Lord's point. Section 2 is directed only at the Constitution. Is there an equivalent obligation in relation to it? We'll endeavour to give you an answer.
Thank you.
Before we plunge into the regulations, the only other thing I wanted to show you was the other provisions in the or explanatory materials in the Health and Social Care Act dealing with Section 6E. Because Section 6E was inserted by Section 20 of the 2012 Act. And the explanatory notes explain what the purpose was that lay behind the insertion of 6E. So if we go back to the supplementary bundle, tab 1, and look at the commentary, it's the Roman 8 in bold at the bottom that you need to look at, starting at note 173.
Sorry, what page are we on?
It's page 8 of tab 1 of the supplementary bundle.
Yes.
173 says the section inserts a new 6E. The section makes provision for the Secretary of State to establish standing rules which would impose requirements on the NHS Commissioning Board or CCGs in the exercise of their functions, do so by regulations. The purpose of the standing rules is that they're intended to allow the Secretary of State to create a rules-based framework for commissioners. When one's talking about a rules-based framework, it doesn't sound much like target duties. They would be generic, and under subsection 8 of the new section, it would not be possible for the Secretary of State to develop regulations only affecting an individual CCG. To a large extent, the purpose of the standing rules would be to allow some existing policies to be maintained in the context of the more limited powers of the Secretary of State under this Act. In exercising regulation powers, the Secretary of State would be bound by the duty introduced earlier in the Act to avoid unnecessary burdens. And then we lay particular importance on 176. Subsections 2 and 3 are intended to allow the continuation of existing arrangements for continuing healthcare and the continuation of certain rights set out in the NHS Constitution, which are currently given legal effect through directions to PCT. So that's a reference to the directions like the 2010 directions we'll look at. For example, the NHS Constitution contains a right for patients to make choices about their care, which is underpinned by directions. Subsection 2C would allow this right to be underpinned by regulations instead, without any need to change the Constitution itself. And at that point, before we get into the 2012 regulations, it's probably helpful to dive into the Constitution and what it contains, because the status of the Constitution at the time the regulations were made, which was December 2012, is of some materiality to the context against which the regulations have to be construed. And what happened very shortly, and I can show you this by reference to the documents, is this. Originally, waiting times started out as a mere pledge. The NHS Constitution distinguishes carefully between rights and pledges. But in 2010, April 2010, directions were made, the consequence of which, or the purpose of which, was to elevate waiting times promises to the status of rights rather than mere pledges. And the NHS Constitution was amended to reflect that change. such that the Constitution in force at the time that the regulations were made reflected the contents of the directions and the understanding that the waiting times in question were to be rights, not pledges. Now, you can see this quite clearly from the version of the Constitution at tab 20. This is the 2009 version of the Constitution. And after the introductory paragraphs saying that the NHS belongs to the people, the Constitution establishes the principles and values of NHS England, it sets out rights to which patients, public and staff are entitled, and pledges which the NHS is committed to achieve. That's the first column of text. If you then go on to the section headed 2A, patients and the public, your rights and NHS pledges to you, you will note that the first pledge...
Sorry, where are we on this?
It's in the page, unfortunately there's no page number. It's on page 4 pages in, headed 2A. There's a big box in the left-hand corner, 2A, patients and the public, your rights and the NHS pledges to you. You can see that there's a list of the various rights identified at that stage. That's then broken by the bold text, the NHS also commits, and everything that follows after that is a pledge. So you've got 1, 2, 3, 4, 5 adumbrated rights, and then a pledge to provide convenient, easy access to services, etc. If one then turns further on into the handbook section of this document, and this is numbered, it's page 4 of the handbook, you'll see rights and pledges are addressed. And this text is the same, so far as we can see, in every version of the NHS Constitution. Under the heading, Rights and Pledges, one of the primary aims of the Constitution is to set out clearly what patients, the public and staff can expect from the NHS and what the NHS expects of them in return.
It's my fault, I haven't seen where you're reading from.
It's page 4 of the handbook, my lord.
Page 4 of the handbook.
Yeah, I apologise, we should have numbered this whole bundle. It's difficult to navigate this particular document.
Thank you.
Rights and pledges, and then under your rights, this is how what is a right is described. A right is a legal entitlement protected by law. The Constitution sets out a number of rights, which include rights conferred explicitly by law and rights derived from legal obligations imposed on NHS bodies and other healthcare providers. The Constitution brings those rights together in one place, but it does not create or replace them. And that's to be contrasted with what a pledge is on the next paragraph. Also contains pledges. The pledges are not legally binding and cannot be guaranteed for everyone all of the time because they express an ambition to improve going above and beyond legal rights. So that's the status of the Constitution in 2009. What then happens is that the directions on waiting times at tab 22 are made under section...
Just before you go on there, we've got the rest of what it says under pledges, that some of the pledges, such as those relating to waiting times for treatment.
Yes.
At that stage, under the heading of pledges.
Absolutely. At that stage, waiting times are exemplified as a pledge rather than as a right. Page 20 again. My learned friend asked me to turn to page 20.
Thank you.
Yes, absolutely right. What we'll see is for each of the rights, there is a box and commentary. I was going to show you this in the subsequent document. And then when one gets to the end of the 6 rights, the last 6th is the right not to be unlawfully discriminated, the pledges start, and here is the full treatment of waiting lists as a pledge. And what we'll see is that that box fundamentally alters in the 2012 Constitution. So the next piece of the equation is the 2010 directions at tab 22. If you turn to their page 6, you can see they're made on the 6th of March 2010, and they come into force, and I can't for the moment find the provision that says as much. Oh yes, section 1.1 come into force on the 1st of April. You can see they're made under section 8, and then one has a series of obligations. Direction 2 is the functional equivalent of what has become Regulation 45. And it's Regulation 45 as originally enacted. Direction 3 is the functional equivalent of what becomes Regulation 47. I mean, Direction 3 and following replicate the choice provisions. And then you'll see, for instance, Direction 6, the duty to have regard to the rule suite, that's the functional equivalent to Regulation 50. The duty to notify in Direction 7, functional equivalent of Regulation 51, and the language is very close, I think. And then Direction 8 corresponds to Regulation 52. So this is, to all intents and purposes, the precursor to the standing rules in Part 9. It comes into force on the 1st of April, at which point the NHS Constitution is amended to reflect that. Now, I think there's various versions of the Constitution before the one that we've put in from March 2012. You can see that perhaps most clearly from the version of the handbook for the 8th of March 2010. So 2 days after the directions are made. Even by this stage, the handbook has been upgraded.
Where are we looking now?
To paragraph, if you look at page,
No, I haven't found the document.
it's tab 21 of the authorities bundle. Forgive me, my lord. Page 4 and 5, you have the same language we've looked at in the previous version, referring to rights and pledges, your rights, pledges, it's all the same. And then when you come to the tabulation in the annex that my learned friend helpfully referred to, waiting times have now been upgraded to the last of the rights. And you see that at page 20 and 21. And what we're told in March 2010 is that this is a new right and there is new legislation to support it, i.e. the directions. From the 1st of April 2010, you will have the right to.
Sorry, where are you reading from now?
Page 21, my lady. And this has now become the last of the rights before the pledges, which start on 22.
And honouring your commitment to Ms Gray, there we have start your consultant-led treatment.
Consultant-led.
Maximum of 18 weeks.
Absolutely. You anticipate my next point. And we're going to see that language in the language of the Constitution itself when it too is updated. So the first updated version of the handbook in March 2010 refers to the right, delivering upon the contents of the directions, and it's formulated in a consultant-led fashion.
The direction is at tab 22.
Correct.
Is that right?
That's right.
And the right on page 20 is to access services within maximum times, or for the NHS to take all reasonable steps to offer you a range of suitable alternatives. Is that language reflected in the directions, or is that, in other words, where's that language come from?
That language comes from the direction, I think, combined with the document that it annexes and refers to.
Okay.
Because Direction 2 is formulated in much more condensed version than Regulation 45. And you'll see there's a reference to Annex 1 of the NHS Performance Framework Implementation Guidance, which I have tried by all means to locate and been utterly unable to locate it. Is it? Oh. Well,
if I may assist, it's not particularly helpful that it was attached at the bottom of the back of tab 21 with the directions. Directions tab 22. It is actually there. There's certainly something there now, I can't find it. Friends.
I must admit, I had been through the various documents that were attached and I couldn't identify.
Tab 22.
Yes.
We have an operating framework. Is that the performance framework?
Well, my lord, it comes directly after the directions at tab 22. And I apologise for interrupting my own friend, but the point you wrote, it is this extremely opaque spreadsheet.
Oh, I see. Right.
That's it. That is Annex 1 to the Performance Implementation Framework. I can say that with confidence because I spent a great deal of time marching through archived DH websites to find it.
Right. And you can see that.
Attached the entirety of the performance framework because we didn't wish to burden the court the document. But you can see that the RTT rule suites are about the third, fourth bullet point down.
And we find that spreadsheet where?
We find the reference to it. I'm so sorry. The actual document is right at the end of the directions, the 2010 directions. That's a 6-page document, and then page 7 is this.
Got it. Thank you.
And my learned friend's analysis, and forgive me, this point had eluded me. I didn't have the privilege of appearing below and being educated by my learned friend then. You can see, bottom right-hand corner, it says 3, Annex 1 to 2009 guidance spreadsheet, XLSX. So the document referred to in direction 2 is effectively a spreadsheet that metricises the performance in question.
Is that, if one looks at Regulation 2,
Direction 2.
sorry, Direction 2, it doesn't talk about any percentages that have to be achieved. But do we get a percentage achievement, whether it's target or absolute achievement, out of Annex 1?
I suspect the answer to that is yes, and I suspect, having only just grappled with this document, it's something to do with the boxes towards the bottom, headed achievement of standards in all specialities, and there's a pass or fail quotient or marker. I suspect the answer to my Lord's question lies in the Excel formula for each box that decides whether or not you've passed or failed, but my learned friend can...
There's also an age, some is highlighted, haven't they? The 18 weeks referral to treatment, admitted, not admitted. And that's where you get 90, I think, 92%.
It's 1990.
Achieve 90% and 95%.
Right,
That's quite right, my Lord. And that reflects, as we'll see, the original text of Regulation 45.
Right.
We're arguing about Regulation 45.3. There wasn't originally a Regulation 45.1 and 2, and that had the differentiated 90 and 95% pass-fail rates, which related to differences between, I think, inpatients and outpatients.
Yes.
So I'll show you that. We put the original regulations in because they're quite helpful.
So if we just come back to page 21 of the handbook,
Yes.
you'll have the right to start your treatment in a maximum of 18 weeks. That's subject to the second half, and that's not in fact a right for any particular individual.
No.
In this direction.
And that's a point I'm going to have to confront. That the right is as to the quality of the service in an overall fashion, rather than a specific right to each and every patient. And I will.
And then we see at the bottom of 21 the exclusions, non-medical consultant-led mental health services.
Yes, that's mental health services. So that there isn't.
Those are out, but there's.
Yes, but that's not.
So it's consultant-led treatment other than non-medical consultant-led mental health and maternity.
Yes.
Sorry, can I go back to the right? The right is a new section 2A of the NHS Constitution, which says you have the right to access services within maximum waiting times, or for the NHS to take all reasonable steps to offer you. So they're linked, or they look as though they're linked.
Yes, the or bit is the bit that's covered by Regulation 47 and following.
I understand that. But are they not connected? In other words, you have the right.
It should be and. Yeah.
No.
No, because it's the or. But this is the wording that appears in Section 2A of the Constitution.
It is.
As amended.
We're going to come on to look at because this is just the handbook. We don't have the Constitution at this stage. The Constitution.
Well, page 20 purports to set out what is in the Constitution. It would be quite helpful to have the whole of the Constitution if people are able to.
Yes, it's in the
supplementary.
It's in the supplementary bundle. So what I put into the supplementary bundle, because I didn't think you wanted every single version from all times. This is, so far as we can identify it, the version that was updated in March 2012. You see that at the foot of the first page. That's the last version that we could find before the regulations were made. So it's tab 3. You've got a nice red page on tab 3. Last line, this interactive version of the NHS Constitution is based on documents first published on the 21st of January 2009 and updated in March 2012.
So, but we haven't got the 2010 version. That was what we've got the handbook of, which was
No.
the point you were making by reference to the directions.
No, exactly. But you'll see the same point effectively reflected in this Constitution and its handbook.
So I'm sure you're right, but if anybody were able to get me the 2010 NHS Constitution, which at the moment is the only kind of document you've shown that there's some statutory authority for having regard to.
Let me show you the contents of the March 2012 Constitution and handbook. So you have on page 2, and it's now helpfully internally numbered and numbered at the right-hand corner. You put it portrait 66. You've got the same text about principles and values. And then at page 6, page 68, this is the Constitution. You have the right to access services within maximum waiting times, or for the NHS to take all reasonable steps to offer you a range of alternative providers if this is not possible. The waiting times are described in the handbook to the NHS Constitution. So there you have the Constitution effectively incorporating the handbook by reference. The point I was making.
So that would appear, going back to the handbook at page 20 that we were looking at, that appears to be in identical terms.
It's in near identical terms. The passage at 4 to 5 about rights and pledges is exactly the same. A right is a legal entitlement protected by law.
Sorry, I was just looking at the actual definition of the right in the second column.
Yes, the only change is that it's now been upgraded to say this is a new right and there's new legislation to support it from April 2010. You will have the right to, and then in all other material respects, I think it's the identical wording to the March 2010 handbook we saw previously.
This is the Constitution, not the handbook.
So this is the handbook.
No, sorry. Page 68
is the
Constitution, isn't it?
Page 68 is the Constitution, correct.
Page 20
is the handbook.
Previous document is the handbook quoting the 2010 Constitution.
So the former Constitution. So that you took.
So I think my lady's point is that the Constitution hasn't changed.
Thank you.
Yes, there must be a version of the Constitution from 2010 that has the same wording.
Yes.
Yes.
The only point from my mind, I was just wanting to clarify, is that when you were tracking us through as to what has changed, we know that by 2010 the pledge has become a right.
Yes.
You've taken us to that.
Yes.
And you've shown us the wording that's in the Constitution as set out in the handbook, although we haven't actually got the Constitution, but that perhaps doesn't matter because it says Section 2A of the NHS Constitution. You've then taken us to the new Constitution at March 2012, and all I was seeking to confirm was that so far as the wording of the right is concerned, that is identical to that which we found in...
Correct, my lady.
So I then used, for my purposes, I'm speaking strictly for myself, I was simply wishing to anchor my own mind on that had not changed before I start to
Correct.
in any alterations you say that we need to take into account.
Correct. What one can infer is that the terms of the 2010 Constitution changed from pledge to right and used text identical to that contained in the 2012.
Been followed through and implemented, rolled over into the 2012 Constitution.
Correct, my lady. So the only other text I wanted to show you at the back of the relevant handout.
Sorry, I'm sorry to slow you down, but I just want to try and see my way through to this clearly. So the new direction in 2010, which we've got in tab 22.
Yeah.
Page 2 has the equivalent of 45.3, let us say.
I think it's 45, 1 to 3.
Actually. And in 3 and 4, maybe following, has the equivalent of 47 to 49. And the way that the predecessors to 47 to 49 are expressed is the same as 47 to 49 in direction 4, namely that the alternative is an obligation to take all reasonable steps to ensure that the patient's offered an alternative appointment. We see that in 4.1.
Yes.
Which is the language also of 47.
I think that's right. I mean,
49.
it's not a straight correspondence, because what the drafter has plainly done is use the directions effectively as a drafting source for Part 9. If you look at, say, 3.7, you'll see the direction, the definition of eligible referrer.
Yes, all right, never mind that for a moment.
Yeah.
The point I'm on,
Yeah.
I just want to clear with you,
Yeah.
is that the language of the handbook, talking about the introduction of new rights,
Yeah.
is that you have essentially the rights in section 2 and 3 to 4.
Correct.
Now, it describes as a right
Yeah.
the alternative provision as your alternative if you don't get your 18 weeks.
Yes.
But that is in the statutory language or in the directions language, a right expressed as an obligation merely to take reasonable steps, not to achieve a result.
That's correct.
Does it follow from that that the language then being used in the Constitution and the handbook was not using right to mean you have an absolute, you individually have an entitlement to have this achieved?
In my submission, the clear and careful distinction between rights and pledges and how those terms are carefully addressed in the handbook at each stage and separately adumbrated in the Constitution itself is intended to set a demarcation line between that which is concrete and enforceable and that which is aspirational, if you like, in the nature of a target duty. And that line between rights and pledges is the line that the Constitution seeks to draw between what we say is a concrete duty.
I quite understand that a member of the public might well think that's what the Constitution handbook meant, but it didn't, did it? Under the law.
Well, with respect, this is one of the features of this case that makes it quite unlike any of the other target duty cases, because the backdrop to these regulations is a document addressed to the public, designed to engender concrete expectations in the public as to what they're to achieve.
I understand that, but direction number 4 is a target duty, isn't it? If we're using that as an obligation to take reasonable steps to achieve something, which we later see in regulations 47 to 49.
Yes, when let's see in 48.1, but of course we're not
and
actually...
that is described as a right.
Yes, it is.
In the accompanying material. And all I'm putting to you is that one can't therefore get out of the accompanying material in the Constitution and the handbook when it describes something as a right,
With respect,
a guide that is in fact what the law provides, because in this instance it doesn't.
With respect, my Lord, that doesn't completely follow, because simply because the words reasonable steps are used in the context of Regulation 48, it doesn't follow from that there is no enforceable content in Regulation 48 in a circumstance where that regulation applies.
I'm not suggesting there's no enforceable content. If they don't take reasonable steps, there's a breach of the obligation.
Absolutely.
But it's a duty of process. It's not a duty as to result.
No, it's not just a duty of process. It's a duty of result as well. Because if you take substantively unreasonable steps, you can be compelled to take reasonable steps.
But if you take reasonable steps and you fail to achieve it because, let's say, there isn't an alternative provider, then
But it's reasonable.
reasonable for you not to have put in place an alternative provider, then there's no breach of duty, and there isn't the right that most people might think, as a member of the public, they were getting if they read the Constitution and the handbook. That's the point I'm putting to you.
I understand the point, but my response is I would still say that there is concrete content in Regulation 48 sufficient to enable it to be meaningfully be described to a layperson as a right.
Thank you.
That's my response. I fully accept that it is a more qualified right than that contained in Regulation 45.3 by reference to that language. So the last thing I wanted to show you in the handbooks, and one can see this either at the end of the version of the handbook from the 8th of March 2021 or from the version of the handbook in the supplementary materials, is the passage right at the end. Find this.
Which one do you want to take?
Tab 21
Of the original bundle.
of the original bundle, last page.
Right, so that's the one we've been working from.
And you can see the right is described, again, quoting from the Constitution, again, further confirmation of my lady's thesis that the Constitution at that time must have had exactly that wording in it. And then under source of the right, directions given by the Secretary of State to PCTs and strategic health authorities on maximum waiting times. They're the directions made under Section 8. And PCTs and strategic health authorities have a legal obligation to comply with such directions. And then this wording, and this was the point I adverted to earlier, the Secretary of State may suspend the directions in certain circumstances or crises, such as an influenza pandemic. Very prescient. Of course, if one was dealing with a mere target duty, you wouldn't need that language. Because as my learned, Mr. Justice Chamberlain's judgment shows, once you're dealing with a target duty, it is inherently responsive to those types of resource allocation or immediate difficulty issues, because it's formulated at a much higher level of generality. And his exact reasoning is, well, there isn't a breach because of COVID. Whereas here, back in 2010, it's anticipated that such is the concrete nature of the direction that any breach will require a suspension of the relevant direction. And we say that's a powerful pointer against this being a mere target duty.
Sorry to ask a boring question. Where does that come from? The Secretary says right to suspend the directions.
Presumably the power under Section 8 to make the regulation, the directions.
Right.
So,
So
any
it's
power to make a
intrinsic in it.
direction.
There's not a separate provision that says in these circumstances or those circumstances they may be suspended.
I don't believe so. We can check that, of course, but I suspect it's more simple than that. It's just the corollary of any power to make an instrument is the power to revoke it.
Yeah.
So that's a very long run-up to, but in my submission, extremely important context for the making of the 2012 regulations. Because what we know is that the purpose of the enabling power, Section 6E, is to give effect to the NHS Constitution and the scheme of rights it creates. It's to create or replicate the legal obligations that that Constitution is predicated on. We know that the directions previously made under previous powers of direction are then effectively ported over into the standing rules contained in the regulations. And then we see the following scheme in these regulations. After Part 1, which deals with interpretation, and regulation 2 here is particularly important because it contains the critical definition of health service provider, as well as consultant, the board, clinical commissioning group, integrated care provider contract, integrated care board, and relevant body. The definitions of health service provider and relevant body that are particularly important. You have the provisions of Part 3, which effectively make the provision anticipated by Section 3B of the Act. It's the provisions entrusting certain functions to NHS England as opposed to ICBs. You have Regulation 6, dental services, 7, armed forces, etc. The relevant one for our purposes is Regulation 11. The board must arrange to such extent as it considers necessary to meet all reasonable requirements. There's the kind of language that is all over all of the provisions of Part 3, and that is, in my submission, redolent of target duties in those circumstances, because it's about the level of provision being required. For the provision as part of the NHL services, the services specified in Schedule 4. And if we then turn on to Schedule 4, the material entries for our purposes are paragraphs 56 and 57. 56 is Gender Identity Development Service for Children and Adolescents. 57 is Gender Identity Disorder Services for adults. So that's the basis upon which NHS England is the relevant body for the present circumstances. But then after Part 3, and starting with Part 5, you have a series of standing rules. And I don't know if you're like me and you hate the Westlaw version because you can never see the headings of any of the sections. So both for that reason and to see what the regulations look like when they were originally enacted, we have at tab 2 of the supplementary bundle the regulations as made. You can see at page 19, Part 5 deals with standing rules commissioning contract terms. Part 6, nursing care. Part 7, very important because this does match up to rights in the NHS Constitution. Standing rules, decisions about drugs and other treatments.
Which page are you on?
Page 31.
Thank you.
And can I ask your particular careful scrutiny of page 32, Regulation 34, which remains in identical form. A relevant body must have in place arrangements for making decisions and adopting policies on whether a particular healthcare intervention is to be made available for persons to whom the relevant body has responsibility. And then 34.2, arrangements under paragraph 1 must ensure that, this is A, the relevant body complies with relevant NICE recommendations. And it's that language, arrangements must ensure that the relevant body does X, an obligation of result, that underpins the entitlement of every patient of the NHS to have any drug recommended as being cost effective by NICE made available for their treatment. Now, the reason I mention that is the language, and we'll see there are other must ensure arrangements type provisions in the regulations. That obligation is deliberately moving of resource. It's deliberately intended to mandate that money be spent on a particular topic.
And is there some authority that puts,
there is.
puts the NHS England in breach if, for example, one particular month GlaxoSmithKline don't have a batch available?
The position, I hope I can fairly describe it as following. I have done a fair number of NICE type cases. The litigation has invariably been about, in this space, about drugs that aren't recommended by NICE.
Yes.
And how to approach the obligations. But the backdrop at each stage has been, if there is a relevant NICE recommendation, you must provide the drugs in question. Because the whole purpose of this scheme, and the whole purpose of NICE, is to end what was the so-called postcode prescribing. And we have a judgment of Mr. Justice J, I can hand it up, in a case called Elizabeth Rose, that touches upon Regulation 34 and explains its effect, paragraph 23 and thereabouts of the judgment, and I've supplied it to my learned friend. But I just mention it because it's a very good illustration of the sorts of provision that these standing rules make that move resource.
But I'm sorry to keep slowing you up, but for my part, I don't see from the language of Regulation 34 that it is an obligation which is breached the moment you don't make a particular nice approved treatment available to one individual in one case.
Well, I suspect.
And I can foresee circumstances, you tell me that they never exist, but I suspect they do in the National Health Service, in which in a particular hospital at a particular time, there isn't a batch of a particular nice approved medicine available for a particular patient for any number of reasons, which may be available the following week. But does that put the NHS England in breach of its duty? The language of Regulation 34 wouldn't suggest so, but if there's some authority to that effect, speaking for my part, I'd like to see it.
I understand the point my Lord makes, but I think we're dealing with the issue at a higher level of abstraction, in the sense that the obligation here is effectively on the relevant ICB to fund the treatment in question. It's not about the physical availability of the drugs. That's what it's all directed. These are disputes about whether or not the ICB will fund or not fund a particular course of treatment, rather than the adventitious, potentially, issue as to whether or not the pharmacy, the hospital pharmacy, has a batch supplied as at that moment in time. And the arrangements are directed to ensuring that they have budget sufficient to meet the requirement to fund treatment with a drug that's recommended as being cost effective. So of course, the circumstances my Lord describes, effectively some form of downstream force majeure or something of that kind, might generate interesting arguments, but that's not where argument has been directed hitherto. In any event, the point I'm trying to make is this. When taking and applying the learned judge's reasoning in relation to Part 9, the court has to be conscious of the ramification that reasoning has for other standing rules with very similar structure or very similar wording. Because if the analysis in this case is such as to undermine the legal enforceability of the right supposedly conferred by the NHS Constitution or ostensibly conferred by it, that reasoning may in turn undermine the other rights that are supposed to be conferred by the other parts. And each of these other parts has matching rights in the NHS Constitution that it's meant to be implementing.
I entirely understand the thrust of your submission, but speaking for my part, I don't really feel able to evaluate it, given that the language here is must ensure compliance with recommendations, without seeing the nature of nice recommendations with which you'll be much more familiar than I am, and any authority there is as to what that means in terms of individual medicines for individual people.
Let me pass on.
I'm not suggesting you need to deal with that now, but for my part, in order to evaluate that submission, I think I might need a bit more educating.
A nice recommendation will be in relation to a particular treatment. It will say treatment of patients with these characteristics with this particular drug is assessed to be cost effective because it delivers a certain amount of quality added life years, which meets the threshold for cost effectiveness. And therefore the treatment is recommended for availability on the NHS. And once that recommendation is made, after a comprehensive process of evaluation of clinical and cost effectiveness, the purpose, I would suggest, of Regulation 34 is to ensure that arrangements are made that that drug is paid for by each and every ICB with responsibility for treating the relevant condition. That's how it works.
It says you've got to have a policy for deciding whether or not a particular healthcare intervention is going to be made. But if there's a nice recommendation,
Correct.
You've got to comply with it.
Correct.
And even so, you've got, that's one. If there is a nice recommendation, you've got to comply with it. if there isn't a NICE recommendation, you've got to have a process for consideration about whether whatever treatment people are asking for that would be not NICE recommended should in fact be funded.
Correct. And that's,
I mean, that's all it seems to me that 34 is saying.
and that's absolutely right, my lady. And what it does within 2A is create a cohort of cases in which the policy condenses into a duty to provide. So, well, I'll arrange for the Elizabeth Rose case to be on your desk, and you can make of it such as you will. I obviously understand the court's reluctance to get drawn into
But
decisions about other provisions.
I mean, I'm just slightly worried that this is a bit of a rabbit hole. I mean, you know, we're spending quite a lot of time on this particular regulation.
I understand, but the purpose is to identify the fact that the judge's reasoning for rejecting the existence of a hard-edged duty, which ultimately comes down to, in very substantial part, resource allocation and the impossibility of relief, would generate exactly the same objection in the face of the language of all of these other provisions.
So this was a for instance.
It's an illustration of the wider impact of his reasoning.
If you're saying this is one example of, you say, the impact of the judge's reasoning.
Absolutely. Exactly so, my lady. So, that was part 7. Obviously, we're dealing with part 9, standing rules. That starts at page 36 of this particular set of provisions. Before we dive into the depths of Part 9, it's probably helpful to look at what the explanatory notes to these regulations say about Part 9. That you'll see on page 62. And it's exactly the same as the standing notes that underpinned Section 20 inserting 6E. It's not exactly the same, it's the same drift. The provisions in Part 9 underpin rights set out in the NHS Constitution, namely the right to access services within...
Sorry, it's my fault, I was making a note. Where are we now?
Page 62 of the supplementary bundle.
Thank you.
There's the equivalent passage. The explanatory notes are also in...
Yes.
So, underpin rights set out in the NHS Constitution, namely the right to access services within maximum waiting times, comma, or for the NHS to take all reasonable steps to offer a range of alternative providers if this is not possible. So there are 2 alternative rights. Regulation 45 imposes a duty to make arrangements to ensure that the treatment appropriate to the reason for an elective referral is provided within 18 weeks of receipt of notice of such referral in a specified percentage of cases. And then regulations 47 and 48 are described, etc., etc. So once again, it's about implementing the rights set out in the Constitution. And then if one goes back to look at...
So sorry, I keep interrupting you, but can I clear my mind on what the status of these notes are? This starts page 60.
Yes.
Under the heading Explanatory Note.
Yes.
Which is published with these regulations on the government
Yes.
website. But we also have
An
a separate document called an Explanatory Memorandum, which is the departmental memorandum one often sees.
Yes.
But what is this?
This
Is this a departmental
is
just note? Or what?
part and parcel of the statutory instrument as and when it's put before Parliament as part of the same document.
But it's not part of the regulation.
It's not part of the regulations, but nevertheless it's an aid to ascertaining the intention behind a regulation. So, my Lord's point anticipates the next place I was going to go before the actual text, which is the explanatory memorandum. Which is at tab 23 of the main authorities bundle. the passages I'd invite you to look at in particular are paragraphs 4.8 to 4.9 of tab 23. And it explains effectively the power of direction has been dialed back, but it's been replaced with the power of regulation making under 6E. The instrument makes regulations under this power, this is 4.9, imposing requirements on the board and the CCG as to the exercise of their functions, largely replicating the existing policy in the new system. I think my learned friend would have you underline that, because the policy has all been formulated by reference to consultant-led, etc. And then 7.18 to 19 addresses the NHS Constitution, NHS Constitution rights. And it's almost in the same terms as that text we've seen in the handbook itself. It sets out what patients, public and staff can expect. Rights in the Constitution are legal entitlements protected by law. They include rights conferred explicitly in legislation and rights derived from legal obligations imposed on NHS bodies and other healthcare providers. The standing rules provide the legal basis for 3 patient rights set out in the Constitution, and it's the third one. Here, the right to access services within maximum waiting times, all for the NHS to take all reasonable steps, etc. Then 8.6, again, my learned friend would emphasise that they are reflecting existing policy, and then there's 2 areas not material for present purposes where there's new stuff. And then 10, impact. This is relevant in my submission. All of 10, and in particular 10.10 by reference to these new areas. All of this is done in the conscious knowledge that these rules will move resources. Indeed, the impact at 10.4 has already been assessed at being in the order of 1.5 to 1.5 billion. Something of a typo, but there's some range in the billions stemming from the combined effect of all of the standing rules. And then at 12, you can see monitoring and review. They'll be reviewed annually and updated as required. And that, of course, has not happened, notwithstanding the COVID emergency. So that's the background to Regulation 45. And the obligation in Regulation 45, which has to be read with the definitions in Regulation 44 and in Regulation 2, is ultimately, when you put all the pieces together, a clear obligation of result, set by reference not to an individual patient, but a cohort of patients. Set not by reference to an individual condition, but by reference to all of the relevant conditions for which the relevant body, be it an ICB or NHS England, is providing the relevant care. So it's an omnibus obligation in that sense. It's not broken out by reference to condition A, condition B, condition C. It's everything for which the ICB is providing treatment or NHS England is providing treatment. And I don't think that there's any dispute between us as to how the mechanical process of calculating the metric is to be undertaken. And that's because, insofar as it's not already clear from Regulation 45.3, and we say it is, there's the rules suite guidance given effect by Regulation 50 that effectively constitutes guidance designed to ensure the uniform and consistent calculation of these periods by each and every relevant body. So the process of calculation has been carefully standardised, and that rules suite guidance, which itself has been through any number of versions. I think there's a 2010, a 2015 and a 2022 version. We have in the bundle at tab 24 the 2012 version. said 2010. There's no material differences between any of these. Sorry, it's at tab 25. It's the rules suite. And you can see executive summary. In England, under the NHS Constitution, patients have the right to access services within waiting times, etc. Para 2, the rules suite aims to set out clearly and succinctly the rules and definitions for referral to treatment, consultant-led, underline the words consultant-led, waiting times to ensure that each patient's waiting time clock starts and stops fairly and consistently. And through a series of case studies and worked examples, it is explained with real precision how this is to be calculated by any reference to any number of difficult cases. And then, interestingly, at 30, and this text appears in every version I've seen of the Rules Suite document, there's a section headed Clinical Exceptions to the NHS Constitution Right. And the entirety of the content of this section is in my submission quite inconsistent with the notion that everything that's preceded it amounting to a mere target duty. Because effectively what is being provided for is the ability to say that in certain cases, for instance, where there is a difficulty in diagnosis, you can't run the clock. Because if you don't know what it is that you're requiring to treat the patient with, you can't say that the time for calculation of the waiting times has started properly. And there are other exceptions, like where the patient decides, for one reason or another, to adopt a course that will lead to a longer waiting time. Now, all of this is strongly suggestive of a regime of exception from something that's otherwise concrete.
Of course, communicating with the patients that longer than 18 weeks is in that patient's best interest is important information for the patient in order to understand whether or not they should opt to access their right to seek an alternative provider.
Correct, my lady. Correct. And there's one further textual indication, I suggest.
But I'm afraid it's my fault. I'm not really understanding why you say this is an indication either way. This is dealing with the minutiae of what does and doesn't go into something that counts as within 18 weeks or outside 18 weeks as the metric, as you've defined it. That doesn't really tell one, does it, whether the duty in relation to the metric is to seek to achieve it or to achieve it.
Well, it speaks to the granularity of what's at issue. And the minute you're engaging with a situation where a patient might have to be consulted on X or Y or Z feature of their condition, or patient-specific considerations are relevant to deciding whether or not that patient is to be admitted into the cohort, you're dealing with a very finely calibrated obligation of result in my submission.
Yes, but forgive me. If it were a target duty, it would no doubt be said, well, in order to show that you're taking reasonable steps to achieve it, you've got to monitor it and acquire data and see how you're doing every month. And that's what this is all about, isn't it? It's all about the capture of data and what goes into what counts as falling within or outside your monthly figure. I mean, is that not equally consistent with the target duty? Is it not entirely neutral?
I see my Lord's point. I do indeed. You're saying that in any event, the measurements have to be taken, and what it is you have to measure has to be measured, and it doesn't bear one way or the other on whether or not it's a target duty. And putting it that way, I suspect you're right, actually. So you could ignore this section.
That's very gracious of you.
Well, no, I mean, if you're wrong, you should admit it, shouldn't you? And just move on. I'm sure it's the dispositive point in this case in any event. Perhaps a better point, before my Lord shoots it down, is in relation to the old contents of Regulation 55. Now this is gone from the version in tab 2 of the bundle, but you can see what was in the old 55 in the old version at tab 2 of the supplementary bundle. And you can see that there is careful transitional provision made in relation to cases that straddle the old 2010 directions and now port into the new regulations. I should say straight away that this is directed at the Regulation 47-48 case rather than a Regulation 45 case. But the whole purpose of Regulation 55, as was to ensure continuity between the two regimes. And this type of transitional provision, I would suggest, is inconsistent with both of those regimes being mere target duties. It's the type of transitional provision that you see where there is a scheme of rights and you want to ensure continuity of the rights. And if that's true in relation to Regulation 48, which, as my Lord has pointed out, has the reasonable, let me use the precise language, reasonable steps language, it must be all the more true that we're dealing with a scheme of rights in relation to Regulation 45. It's a strange provision to include in relation to what amounts to no more than a scheme of target duties. Again, not dispositive, but a helpful textual indicator. I should also show you, just to make good the point I made to my Lord Justice Moylan, that the original version of Regulation 45, at page 37 of this supplementary version, was considerably fuller. And in what was the old Regulation 45-2, you had the split between 95 and 90%, which you saw in that table my learned friend helpfully pointed you to. And of course, in relation to this particular waiting time obligation, the Secretary of State has plainly chosen to remove it, for whatever reason. That has gone, and all we're left with is Regulation 45-3. So that's the scheme of the regulations, which I know you've pored over. Let me now, relatively swiftly, address the case law on target duties. And the starting point is, of course, this court's, not this court, the divisional court's decision in the Alley case. Lord Justice Wolfe, as he was then sitting with Mr. Justice Pill. Tab 5 of the authorities bundle. It was litigation about Section 8 of the Education Act, which was, in analogising terms, loosely correspondent to what we see in Section 1 or Section 1A of the National Health Service Act. You can see the terms of the statutory provisions at page 826. The target duty in 8.1, it shall be the duty of every local educational authority to secure that there shall be available for their area sufficient schools for providing primary education, secondary education, and the schools available for an area shall not be deemed sufficient unless, etc., etc. If you turn over the page, can I ask you to note at 10.1 of the section, the Secretary of State has the power to make regulations prescribing the standards to which premises of schools maintained by local authorities are to conform. Now that is the functional analogue of the Section 6E power that we're concerned with, and the regulations, if the Secretary of State had made them, would be the functional analogue to the 2012 regulations with which we are concerned. And then if you go down further, at Section 99 of the Act, there was a relevant power of direction. Now what this case concerned was an alleged breach of Section 8 in circumstances where there were no Section 10 regulations and where there was no Section 99 direction. And the first question was, what was the nature of the duty in Section 8 and was it enforceable? And the court answered that at 827 and following under the heading, the interpretation question. And it's in particular the language at 828b and following that is material, and it identifies that Section 8 is very broad in general terms, and it's a counterpart of an even wider duty upon the Secretary of State placed by Section 1. So the local authority's duty mirroring to some extent the Secretary of State's duty. And note, the precise analogy made is, well, it's a bit like Section 1 of the National Health Service Act, 1977, which indeed it is. And that type of duty is a target duty. And it's because it's a target duty that the generous approach is adopted, and why is explained in 828D and following. And in particular, I draw your attention to 828H, where Lord Justice Wolfe says he wouldn't accept Mr. Gowdy's approach, that it's entirely for the local education authority to decide what steps it should reasonably take. And that approach would be inconsistent with the fact that the Secretary of State is not only given the power under Section 68 to intervene, he is also given the power to intervene when the local education authority has failed to discharge any duty imposed upon him under Section 99. In other words, one of the reasons why it wasn't open-texted was there was a power to make direction requiring a particular thing to be done. And then the analysis at 829, drawing upon the Ward case, points out that the key feature in all of this is that the reason for latitude in relation to target duties is because what they call for is an evaluative judgment, a value judgment, taking into account all of the relevant circumstances. And that, obviously, to use the more sort of modern language of judicial review, creates a problem of justiciability, where you have completing claims for resources. You hear public law advocates talking of a Lon Fuller type problem, and that's the problem with resource allocation decisions. They call for, ultimately, things that most of the time amount to political judgment, how best to discharge the duty in question. And that's why the duty under Section 8 is not absolute. Now, there endeth the passage cited by the learned judge, but in my submission, that is not the entirety of the relevant analysis in this case. Why? Because one of the things that the court had to confront was a more ambitious argument from Mr. Gowdy to the effect that there was simply no jurisdiction to deal with any questions in relation to Section 8. And that is addressed at 831 and following. And in it, the court opines, in my submission, extremely materially upon the relevance of directions that might have been given under Section 99. Because what it's effectively, the court's analysis, is that there is jurisdiction, even where no directions have been made. It's discretionary, and it should be exercised very carefully. But the critical passages are E to F, where he says, until the power to give directions has been exercised by the Secretary of State, it would be difficult, if not impossible, in practice, in most such situations, for the court to intervene at the behest of the Secretary of State. The duties placed on the local education authority are so broad as to not be readily susceptible of enforcement by an injunction or by an order of mandamus, unless they can be linked to directions. And what this shows is that the court is anticipating the very point I made to you this morning, which is a target duty is one thing, hands off, politics. But once the target duty has been fleshed out by directions into ascertainable concrete obligations, the reticence of the court to get involved diminishes. And that, of course, is precisely what had not occurred in the Ali case and has occurred here. Now, further confirmation of that thesis is provided by the next case in the bundle, the Rickson case. It's a very complicated case indeed. But in that case, there was a mix of target duties and directions. And the essence of Mr. Justice Sedley, as he then was approached to all of this, was to reject the claims made by reference to the target duties, while embracing and to some extent accepting the arguments made by reference to the directions. And again, the passage cited by the learned judge from Rickson and the passages drawn on in the judgment are directed only to the target duty passages rather than the passages dealing with the directions. Now, page 6 of the transcript, the unreported report, you can see the scheme set out. And this is the part quoted. Some of the relevant legislation contains what are known as target duties, phrase coined by Lord Justice Wolfe in Alley, etc., etc. But if you go on to page 11 through to 12, you will see that parts of this complex statutory framework were fleshed out by directions. And in particular, you can see that Section 29 of the National Assistance Act had provisions for directions to be made, the effect of which is to make mandatory what is otherwise discretionary under the section. And then you see at the foot of 11, the Secretary of State has given such directions, initially in 1974, and now in a consolidating measure captioned Secretary of State's approvals and directions under Section 29(1) of the National Assistance Act, 1948, one of the snappier titles around, published as an appendix to a departmental circular. And then the terms of the directions are set out before the judge concludes at 13 what the overall scheme is. When you then come to look at how the judge parses the arguments, in particular at 26 through to 28, you'll see that it was Miss Richards' pointing to the specificity of the directions, foot of page 27, as the distinguishing feature of the present case, and the narrowing of her focus that effectively got her home, but that was the question that had already been addressed in the earlier part of the judgment, such that she couldn't pull herself up further by reference to the general provisions of the General Act. This case's authority, if anything, for the importance to focus upon the end product, not the target duty, or not the enabling power for the end product, namely the directions or regulation. I can't help but notice that there is a Miss Gray with an A referred to at the end of it, which I suspect was my learned friend, but probably lost in the mist of time. I can't remember what I was doing in 1996, and I suspect she can't either, since she was sent along to argue about relief. But it seems like a rational inference that she was covering for her colleague, Miss Richards.
No memory whatsoever.
No.
Am I right in thinking that there was in this case a statutory duty, which it was common ground, was an individual duty, not simply a target duty?
Yes.
In section 2 of the...
Yes. That aligned with the individual directions was what the case ultimately turned on, not the general target duty.
Irrespective of the directions, if one looks at the bottom of page 8.
Yes. Yes, I accept that, my lord. But both the directions and that duty got you to an individualised assessment. The point is that Mr. Justice Sedley, as then was carefully distinguishing between the target duty and the content of any directions or any other individuated duty. And he was saying that you're not going to get home on the target duty in circumstances where there's a direction concretely addressing the particular point at issue. So that's the second case, Rickson. The third case is the family planning case at tab 8. and can take this very quickly indeed. Because the case is ultimately about what relief should be granted if the relevant duty is a target duty. And in that case, there was a target duty. Article 53 of the 1972 order effectively reflected the target duties in what is Section 1 and 1A of the National Health Service Act 2006. But the total non-provision of abortion services in Ireland was nevertheless held to breach the target duty. So even target duties can be breached. They're just that much harder to pin down. And after reciting the effect of Ali at 11, you get the conclusion above 12. In the present case, the default power to be found in Article 53 of the 1972 order does not relate to a default on the part of the respondent in the event of its failure to discharge its functions under the order. I do not consider the department in the present case is doing all that it simply can to meet the unqualified statutory obligations imposed on it by the terms of the 1972 order set out above. So it's a case where, notwithstanding the fact that it was a target duty, the target duty was breached. And that is how the Lord Justice, Mr. Justice Chamberlain rightly understood it at paragraph 62 of his judgment, page 80 of the call bundle. Then we have Ahmad taking the cases in chronological order, which is at tab 9. This was a House of Lords case about the legality of a housing policy and how it allocated housing between different cohorts of people covered by the relevant duty. The relevant housing obligation was obviously owed to the population of the borough at large, and it was this fact that Baroness Hale drew attention to in paragraph 13 of her speech, page 760 to 761. This is the passage the learned judge below drew upon, and he drew upon it for the proposition that there's a difference between obligations identifiably owed to individuals and obligations owed to a larger cohort of people. It's redolent of the themes in the Tandy case, which I'll come to in due course. And effectively, Baroness Hale is saying there's a fundamental difference in public law between a duty to provide benefits or services to a particular or for a particular individual and a general or target duty which is owed to a whole population. But of course, that begs the question as to whether or not every duty generally identified is in fact of that character, or whether or not it contains an obligation of such specificity of result that it nevertheless amounts to a conventional duty. The type of duty at issue in that case was largely open-ended as to result, and it contrasts very differently to the duty in play here, which is to deliver a concrete, measurable, metricised end result. And so we would suggest that the reasoning of Baroness Hale in 13 doesn't really ultimately assist in a case where the nature of the duty as drafted is so very clear as to the end result required and doesn't leave one with an open-ended resource allocation, use your best judgment to choose between different results or different parties type problem of the kind that is the classic target duty issue. So that's Ahmad. And that reading, we would suggest, is reinforced by the conclusionary words of paragraph 16 of Lady Hale's speech, where she says section 1676 makes it clear that, subject to the express provisions, it is for the council to decide on what principles the scheme is to be framed. Well, there is no equivalent decision here. it is not for the ICB or the NHS England to decide what level of weighting is or is not acceptable. That question is answered for them by the duty imposed by the relevant section. Then we have Hunt, which is at tab 12. Paragraph 12, which we cited below, and I think again here in favour of our support for a declaration, merely encapsulates the principle that if you've won in your argument of law, then in principle, all things being equal, you're entitled to the court exercising its discretion to grant you a declaration reflecting that legal victory. The balance of what came at 13 and follows flowed from the particularly odd circumstances of the Hunt case, which is they hadn't even sought a declaration. They were having a battle in the Supreme Court, I think it was by this stage, as to who had won and who should get costs. And so 13 and following was a battle on such cost front. And it was in that context that the court made the comments it made at 16, which are picked up on by the judge below, where they said there are also wider public factors to consider. Public law is not about private rights, but about public wrongs, as Mr. Justice Sedley said in Dixon. And the point being driven at there by Lord Toulson was that in the battle about whether or not there had been a public wrong, the relevant claimant was the winner because they had established that there was a public wrong, even if that wasn't encapsulated in a declaration. And for that reason, they were entitled to a substantial portion of their costs. Now, with respect, we don't really see how that discussion illuminates anything in the present context. The question here is whether or not there's a public wrong in the sense of a contravention of a clear and unambiguous and enforceable duty. If there is, then we're entitled to declaratory relief, as paragraph 12 sets out. If there isn't, then the judge's decision is immaculate. But simply formulating the question by reference to public wrongs contrasted with private rights doesn't help, other than to make the obvious point that it is not necessary for there to be some form of strict Hoffeldian correlation between the public law duty and an enforceable private law right on the other side of the equation. It's not necessary that every public law duty has, in the narrow private law sense, a right at the other end of it. And to some extent, therefore, that's the answer to the question my Lord was posing to me earlier about whether or not the NHS constitution was being precise in its language of rights. My submission would be that the NHS constitution is not talking about rights in a private law sense. It's talking about what enforceable expectations you're entitled to have as a matter of public law. You can't sue for breach of statutory duty for a contravention of the NHS constitution. And that's because it's not a private law right. There's no breach of statutory duty. But there is a right in common parlance and in public law parlance, because there is a restrainable or identifiable public law wrong. A public law right, if you want a neologism to capture it. So that's Hunt. And then the last case, Justice for Health, tab 14, decision of Mr. Justice Green. Complex dispute about the terms and conditions of NHS employment, you see from paragraph 1, in the course of which the judge, as is his thorough trait, engages in a very detailed landscape review of the operative law. And at paragraph 79 and following, under the heading, The Legal Framework, he begins by setting out all of the relevant target duties applicable in the NHS context. And that is the content of 79 through to 89, culminating in 89 saying that these are all target duties, because although cast in mandatory terms, they lay down broad objectives to be achieved and impose upon the minister the obligation to act in such a way which is designed to achieve or secure the objective. They are target duties in the sense that they do not specify a particular or precisely defined end result. We agree that is the essence of a target duty. It doesn't specify tightly a defined end result, whereas Regulation 45.3 does. And their mandatory nature is diluted by the fact that they do not compel the achievement of that end result, instead requiring the Secretary of State only to factor those objectives into consideration. Again, we agree. But what was omitted from this account of the judgment, again, is the passage starting at 97. Because at 97, the judge goes on to say that there are express powers of compulsion, and that the NHS Act 2006, in addition, confers upon the Secretary of State certain powers of compulsion in relation to particular bodies and entities, not all of which are relevant to this case. Thus, for instance, and then C, under Section 6C, the Secretary of State may impose requirements on NHS England or clinical commissioning groups in relation to the commissioning function. And it is plain that the judge there is rightly drawing a contrast between the vague, open-ended, non-obligatory in terms of end result target duties addressing at 89, by contrast to the sorts of things that may be required exercising powers of compulsion under 97. This case is yet further proof of the Ali-Rickson thesis that what you have to concentrate on is the powers of compulsion themselves and the fact that they are intended to be powers of compulsion. They are intended to clothe target duties with meaningful and enforceable obligation. So those are the cases. Let me then proceed swiftly to our submissions. I'm obviously not in opening going to address my learned friend's respondent's notice. I'll pick that up fairly briefly. Suffice it to summarise our position as follows. We fully accept that there are all kinds of indicia that the intention and the policy was only to implement RTT in relation to consultant-led services. You see it in the guidance document, you see it in the rules suite, you see it in the language of the NHS constitution itself. There's lots of references to it. But the basic problem, as identified by the judge, is that the language of Regulation 45 is unambiguously clear. It is impossible to read into Regulation 45 any limitation on the language, and the relevant language is the definition of health service provider, not eligible referrer, that limits the parties to whom a relevant reference may be made, elective referral, to a consultant-led team. And with respect, we simply don't understand, as a matter of mechanics, my learned friend's argument that somehow limbs 1 to 3 of definition D of eligible referrer should be read into the other limbs, because it doesn't answer the problem. As the judge said, the problem is in the breadth of the term health service provider, not in the breadth of the term eligible referrer. It's the person to whom the reference is made that becomes the relevant body. And that's why the argument is, however one looks at it, seeking to recast the terms of the regulations. Now, it's very important in this context to observe that the INCO test, which the judge rightly applied, is set in the strict forms it is. We are, again, in the realms of public law, not private law rectification. We don't have the device you fall back on in private law when you seek to rectify, which is the common intention of the parties. This is about the meaning that will be attributed to the legislation. And it is an extremely slippery slope to start to substitute the clear language of statutory provisions with background materials so as to fundamentally alter the meaning, the clear meaning of the words on the page of the paper. It's a very different exercise to the one we draw upon the materials for, which is simply to ascertain in general terms the underlying intention.
Well, it's still a question of, isn't it, of defining the meaning of the statute, albeit it's in the context where the words literally, plainly have one meaning. It's not. It's still an exercise in statutory construction.
It runs into the limits of the D case that my learned friend has herself cited, and I'll address that in reply. But there is a clear difference between using an explanatory memorandum or other materials to explore an ambiguity and using it to rewrite the terms of a provision that's otherwise entirely clear. And we plainly cross into the latter realms, as the learned judge correctly found below. It's not exploring an ambiguity and choosing between alternative meanings, it's supplanting the clear meaning with a different meaning. And by a mechanic, with respect, I still don't understand, because we still don't know what the statutory provision is meant to say in consequence of reading in paragraphs 1 to 3 and how it will work. And it leads to a nonsense if you start rewriting the definition of eligible referrer, because when you go to the language of Regulation 47, the first condition in 47.2 is an eligible referrer has referred the relevant condition. 47.3 then narrows it down to the references to a consultant-led team. If you start tinkering with the definition of eligible referrer to do all the heavy lifting, as my learned friend urges upon you, the entire scheme of Regulation 47 becomes unworkable. Anyway, that's the gauntlet we put down, and I'll listen carefully to what my learned
Does it
friend
become
says.
unworkable, or does it just become unnecessary?
Well, it becomes...
I mean, I quite understand that because you've spelt out the consultant-led in Regulation 47, if that's what eligible referrer meant in the first place, you wouldn't need to do that. It would just say eligible referrer. But is it...
But I didn't understand, I do have the primary problem, I don't understand how altering the definition of the eligible referrer solves the problem when it's the definition of health service provider that has to be amended. Because the critical thing on my learned friend's case is not who's referring. You can refer if you're a GP, you can refer if you're a general dental practitioner, you can refer if you're someone, a consultant, that said they're happy to have a reference from, is how it works. I don't understand how tinkering with that definition alters the question as to whom must the relevant reference be made.
I understand your point that you would expect the limitation to come in the identification of the referee rather than the referrer. But in fact, the language uses eligible referrer to define, as part of the definition, of the start date, and therefore to get you within the cohort. So if you can manipulate, you say impermissibly, eligible referrers to be confined to those who are referring for consultant-led services, that does the trick. I can't understand you say that's not something you can do with the language of eligible.
With respect, I still don't understand how that actually works.
Well, so it's the hard stop in D. Suppose that D in eligible referrer stopped after any other person, and then all that followed made clear that it was to qualify A, B, C, and D. Medical practitioner, dental practitioner, and so on. Just suppose that's how it had been formulated, so that all eligible referrers had to be referring to consultant-led services. Then that would that you wouldn't get a start date unless the referral was from someone referring it to consultant-led services.
You would have to read in effect, eligible referrer means 1, A to D, with a stop after any other person, and 2, any such reference must be to a consultant, blah, 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 blah. I mean,
that's what the judge said was something that you simply couldn't do by rewriting the language, and what would have to be done by to put a hard stop after D if you wanted to get to the result.
I mean, his reasoning is unimpeachable in my submission, and what's more, it's particularly hard when this whole definition has been ported over from the use made of the definition of eligible referrer in the old direction 3 of the 2010 directions, where this definition, I just don't understand how it works. How would anyone advising begin to say that that's what this regulation actually meant at the time? They'd say, well, you may have not captured your intention, but the legal effect of this provision is perfectly clear. And that's what the judge concluded, and he was right to conclude it. So that's the respondent's notice. Can I just then...
Can I just ask you, you may want to deal with this later, but do you put forward any rationale for there being a different cohort for the purposes of the duty in Regulation 45.3 from the cohort to whom the Regulation 47 duties are owed?
I would be in entirely the realms of ex post facto rationalisation.
Can you posit?
Yes, I can posit one, which is that it's perfectly rational to confine the process of choice as between choices in consultant-led teams, where there's likely to be statistics about the relevant success rates of the consultants, etc. It's all part and parcel of a regime of changes designed to support patient choice in the NHS. And it makes perfect sense.
Sorry, can I just confine the choices? This is for the Regulation 47 to consultant-led teams where there's likely to be data.
Statistics on consultant success, operation success rates, all the things that other provisions in the regulations require the publication of. Because patient choice isn't confined to this at all. It's supported by other provisions in the regulations requiring transparency. And it seems like a perfectly rational thing to say that in relation to certain conditions which are led by consultants and consultant teams and are likely to have team-based stats as to the performance of that team, that you are exercising a choice between those teams, and it might not apply in other areas.
If you're right, you will get those captured in the RTT data. So why then shouldn't that be included in the...
Well, the RTT data is going to capture waiting times. Yeah. It's not going to capture other metrics about the relevant performance and success of the relevant team. So when exercising your choice, you've been delayed for 18 weeks in seeing a particular, let's say, consultant, for the sake of this argument. You have a choice. Do I move to another team and exercise my right of choice under Regulation 47 and 48 by moving to this other team? Well, one of the things that's going to inform that is what I infer as the relevant expertise, qualification or quality of the team in question, which I ascertain not from their waiting times, but from their success rates. So actually, do you know what? I think A is better than B. I'm content to wait longer than 18 weeks for A because I want to be treated by A, not B.
And is that something, that additional data, that is universally available for all consultant-led services and universally unavailable for non-consultant-led services?
I'm going to be...
So I see your point. If that isn't so, I'm afraid I don't understand your point.
I'm going to have to go back into, because there are other provisions in the NHS Constitution, and indeed I think other provisions in the regulations dealing with this, and there are obligations onto what data you have to publish. I suspect my learned friend is going to know the detail of that better than I do, but that is my best rationalisation as to why you would confine the later obligation to a choice between consultants. If it's only in relation to those types of teams, you get that granular type of output data. So the key question for the appeal is, where has the learned judge gone wrong? And the key passage for our purposes, after his review of the authority on target duty, starting at section 73 and following, that goes through the cases I've just taken you through, is the passage beginning at 86 under the heading, the principles to be applied, page 86 of the core bundle. I do make all the points I made earlier about aspects of those decisions that have been missed, aspects of Ali and Rickson and Justice for Health that have been missed. Because one of the features of the reasoning that follows at 86 and following is that there is no account taken of the fact that the purpose of these regulations was to clothe out a target duty. It had been done by directions formerly and was now done by regulation. And the purpose of those regulations was to give effect to rights identified in the NHS Constitution, which were intended to be legally enforceable, legally binding, and which were intended to move resources, to compel allocations of resource so as to secure that the right in question was delivered. The starting point, we're all agreed, is an exercise of construction. And the first point for any exercise of construction is the language of the provision. And the language of the provision must ensure, etc., is as plain as can be.
But it doesn't say must ensure. It says make arrangements.
Makes arrangements to ensure.
It could on the one hand say must ensure, which might more readily be capable of saying that, obviously achievement-based. Or it might, on the other hand, have said make arrangements with a view to ensuring, which is more obviously target-based. But it's somewhere in the middle. It says make arrangements to ensure. And
that's a fair point, my lord.
As a matter of language.
And what I must address is why it refers to arrangements, yes, and whether or not the words arrangements, which then become critical on this analysis, yes, operate to dilute the obligation to, otherwise would be to ensure that at the end of the data collection period, etc. And our submission is that there is no particular magic or diluting effect to be winnowed out of the words arrangements. All that is a reflection of the fact that this is a duty typically directed at an ICB, not the NHS England scenario. And typically ICBs discharge their duties by the arrangements that they have entered into with multiple healthcare providers.
Well, that's also true, isn't it, of NHSE in relation to...
It may or may not be in relation to...
NHSE only services, if I call them those.
But it's more a characteristic of NHSE services that there may only be one provider, not least because lots of the things in Schedule 4 are rare conditions. So there may well be only one specialist treatment centre for a particular condition. There are a number of rare conditions identified in Schedule 4. They're
quite broadly defined, maybe in practice, but
yeah,
specialist heart services, specialist renal services, specialist almost every kind of service.
Yes, but the principal target of this regulation has to be the CCG or the ICB. And the way that CCBs or ICBs, and indeed for that matter in many areas, the NHS England, discharge their obligations is by making arrangements, not just with one provider, one foundation trust, but multiple providers.
Well, is that not equally true of NHSE
in
relation to the duties we're talking about?
It is, yeah, it is. And that's why, because you're dealing with commissioning, the obligation is to ensure the effect of those arrangements. If there are 4 or 5 or 6 different hospitals with which you've contracted for the purposes of X or Y or Z condition, or if you look at Regulation 52, it's exactly the same in relation to cancer. 52 is a relevant body must make arrangements to ensure that persons for whom they have responsibility, etc., in relation to cancer patients, exactly the same structure. The cumulative effect of those commissioned arrangements has to be to deliver waiting times better than or equivalent to the 90%, 92% figure. So all that the words arrangements are speaking to is the fact that we're in a commissioning context where the relevant body with the obligation has to commission services in order to enable it to deliver upon the duty in question.
But can I put something to you? That may be outside the power of the commissioning service. Take, for example, a junior doctor strike for a month, as a result of which a large section of the health service switches to acute care and not to the elective services with which we're concerned. That may result in falling short where otherwise you would have met the 92%. Now, the focus on making arrangements is that all NHSE or ICB may be able to do is make arrangements for the normal provision, but they can't deal with all contingencies. And it may be said, well, that's why the focus is, the duty is to make arrangements, not to achieve a result, because the result is in some circumstances going to be beyond their control. What do you say to that?
Well, I say to that that's principally a matter that goes to whether or not it's an issue in relation to which the court would grant relief. It doesn't follow that every single breach of a duty triggers relief on the part of the court. But the problem is, once you formulate a duty in these terms, seemingly strict terms, you have to bear the consequences of it. And in multiple instances, one can formulate circumstances where a breach might technically occur or occur for reasons outside the control of the party in question. You can't use that to effectively backread or alter the plain words of the section in question. So, yes, my lord's absolutely right. One can posit an example like that, and it may be that the proper response to that is to say, well, if it's a continuing breach and it occurs for a protracted period, the better course is to remove the obligation in question or to recast it or to provide an exception or exemption that applies in circumstances like that. But that's not what this regulation does, and that's not the nature of the promise made to the public. And when we come back to that problem, you've got to look at this language, it's going to be my second point, against the context, which is that everyone is being told that this is intended to create a legally binding and legally enforceable right on the part of the patient. Rights, as opposed to pledges, are meant to be legally enforceable. The explanatory notes to section 6E tell us it's intended to implement rights in the Constitution. The explanatory notes and the memorandum to the 2012 regulations tell us that that's what it's meant to do. And the minute one turns it into the kind of very loose target duty that the judge does, it's not in any way identifiable as any form of right at all. Such that even protracted breach, and it's at this point it's worth going back to the underlying facts. The National Health Service England has been in breach of this duty since long before the COVID epidemic started. The figures are much worse post-COVID, that much is true, and that's true of ICBs as well. But the breach occurred well before COVID, and for a number of years. And there was, as I understand it, consideration and consultation given as to whether or not the terms of the duty needed to be amended in consequence. So, I do say the public has the entitlement to expect from the wider context that the government is doing what it says it's doing, that the regulations are doing what they say they're doing. I mean, we cast this as a kind of consumer problem. If you were told that you would be given a legally enforceable right to ensure that you had a waiting time of a service quality that would deliver in 92% of cases an 18-week turnaround, and then you were told that there was no such thing at all, you'd call that bait and switch. And there is a whiff of that about all of this when one contextualises what is now said about this duty against what has been said about it repeatedly in the public pronouncements about it. And that really is the answer to the promise to a population at large argument, or the judge's argument at 93, which is, well, you could comply with this duty whilst waiting times for the treatment of those with gender identity problems were catastrophic. Why? Because there's a cohort that's much wider than the cohort for any particular form of treatment. That entirely misunderstands the nature of the promise. The nature of the promise is as to the overall quality of the service. It's a promise about structural promptitude within the service. It's exactly like a promise that says, for instance, the post office will deliver 92% of letters within 2 days. It matters not from a public law perspective whether or not you're one of the 8% whose letter is late. You have an identifiable and enforceable promise. That's the performance metric you're entitled to insist upon in relation to the service. And if you have standing as a matter of public law, you can then complain about the absence of the quality of the service, whether or not you have been personally impacted or affected by it, on which subject there is no doubt that the appellants that I represent have been personally impacted and affected, and in circumstances I don't need to elaborate, causing a great deal of distress as they have waited many years for treatment. But the promise that has been made is to the public at large, but it is as to a service of an identifiable quality. And there's no ambiguity as to what that quality of service is. You shall enter, at the point that your reference is made, a service that will deliver for at least 92% of people treatment within 18 weeks. It's a quality-based promise. And that, with respect, answers the point that the judge makes at 93 and comes back to at 96. And that's why we say, when one gets to the reasoning in question, you get to a position where excessive weight is attached to the words make arrangements. Excessive weight is identified to the fact that it's a cohort duty, whilst ignoring the fact that it's an obligation of identifiable, closely metricized quality. No sufficient attention is paid as to the origins or structure of the obligation, namely that it started off in directions, ended up in regulations, and the entire legislative purpose of the scheme to implement regulations is to clothe out an upstream target duty. So no attention is paid to the fact that we're now having a target duty that's the son or daughter of another target duty, which is at odds with the analysis in Ali, Rickson, and Justice for Health. I'm not saying it's impossible, of course, by regulations to create some tighter form of target duty or something closer down the road to an actual duty, but still having characteristics of target duty. But nevertheless, the purpose behind the regulations and their intention to deliver upon the rights is an incredibly important pointer in my submission. And then one comes to what appears to be the dominant concern in the judgment, which is that starts at 95 through to 99, and it's the twin concerns of the impossibility of relief and the consequences in terms of resource allocation. And in our submission, those are both rank bad points. The whole reason why relief is discretionary is to save the court from intervening by way of mandatory order in those circumstances where there may be a breach of duty, but it is nevertheless constitutionally inappropriate for the court to intervene by prescribing the solution. And the more complex the problem is, the more inappropriate it may become to intervene by way of mandatory order. And that is, if you like, the client earth dilemma, where you have, at the end of the day, a clear obligation of result, air quality standards to be achieved by a certain year. Breached, does the court then police and monitor the making of an air quality plan or a matter of that kind? A very difficult topic, and one we've eschewed, because we've confined the relief we seek to a declaration. It doesn't follow from that that the nature of the duty in question isn't ultimately concrete in the way that the post office example I gave you would be, or an air quality obligation of result would be. It just mediates or affects what relief is appropriate in which circumstances. And you can't infer from the fact that a party has confined itself to seeking declaratory relief that there is no duty at all to be enforced. That is a non sequitur. As for resource allocation, as I've sought to explain to you, the regulations themselves contemplate in section 10 of the explanatory memorandum the fact that they will have profound resource implications. 1.5 billion was the figure. And of course they do. And if you go through each of the standing rules, implementing an obligation to adhere to nice prescribing guidance will have a resource implication. Honouring patient choice and allowing patients to choose which providers to go to will have resource implications. They all have resource implications. That's the whole point of providing instruction. The purpose behind the instruction is to require the relevant commissioning bodies to allocate resource to deliver upon the promise in question. And one can't then pray and aid the fact that that is the consequence of the right as a reason for saying it's not a right at all.
That may have resource consequences. It may be that even in the context of foreseeable events like strikes, they could devote sufficient resources so that there was a lot of spare capacity, most of the time unused, but enabling an 18-week waiting time to be met in 92% of cases in the most extreme and unfavourable conditions. But that would engage all the sort of socio-economic and resource political considerations which traditionally are not regarded as matters for the court to determine by reference to absolute duties.
The problem with respect, my lord, is this. The judgment at 97 says, after setting out position on the declaration, this is, as it seems to me, an acknowledgement that one purpose, even perhaps the principal purpose of these proceedings, is to encourage NHSE to spend a greater proportion of its budget on directly commissioned services. But just as it would be inappropriate to order NHSE to do that, so too it would be inappropriate to grant relief which encourages that outcome. And that's then effectively drawn upon in support of the conclusions on duties more generally. But the answer to that is, if that is the explicit purpose and intention behind the regulations, properly understood, in other words, to say there is a right, you have an entitlement to this, whether it's nice prescribing, whether it's tedious treatment within an 18-month time period, and you, the ICB, must spend the resource required to deliver on that, it can't be an answer to why that's a duty to point to the fact that there are resource implications in the delivery of the duty. If that is what the legislator, here the Secretary of State, has gone into eyes wide open as requiring to be done. That's the problem. The reasoning is not even circular. It's illogical because, first of all, you have to ask whether or not that was the purpose of the regulation in question. If it was, the fact that it leads to resources being allocated is a very good reason for enforcing the law, because that's what the law requires.
Yeah, but it's not circular, is it? Because in deciding whether that is or is not what the regulation requires, it's relevant to consider whether construing it as a requirement would involve imposing an obligation into the allocation of resources, which it is unlikely that Parliament would have intended in the delegated legislation.
But with respect, that begs the question, why is it unlikely that Parliament would have intended it, when it seems that was the very explicit purpose of Parliament enacting in so doing? Well, it's not unlikely.
And there you're stating what you're setting out to prove.
Well, take the example by reference to NHS prescribing. That's a really clear, nice prescribing, that's a really clear-cut example. If there is a duty to provide that funding, it has to be money is found to meet the costs of prescribing nice treatment that won't be available for being spent elsewhere. It's the clearest, most unambiguous signal, this is how you must spend your money. In other words, the Secretary of State is forcing a resource allocation of a particular kind, thereby affecting other choices, eliminating other choices that may be made. Now, if that is the effect of Part 7, why is it so outlandish that that is actually the effect of all of the parts? And they're all directed at ensuring that the relevant rights identified in the NHS Constitution shall, no matter what the cost and no matter what the other resource implications are, be delivered. And that is the issue in our submission. That's exactly what the regulations intend to do.
Now, is that a convenient moment
I think it's the moment, because I will check my notes, but I think I've covered virtually all that I intended to cover in the time I agreed with Ms. Gray.
I was going to ask you how you're getting on, but it's let's.
I might have at most 5 minutes worth of material. There have been, I don't intend to moan by this, a lot of questions, but
understood. Yes. Well, I think we're fine for time, aren't we?
Yes, indeed. This was the agreed time.
Yes. So we'll say 2 o'clock, and we'll hear your final remarks. Thank you very much.